Schovanec, correct?
Yes, sir. That's correct.
Thank you. Please raise your right hand. Do you swear or affirm the testimony you are about to provide is true and accurate?
I do.
Thank you. Mr. Dubinsky or Mr. Leonard, whomever.
Thank you, Your Honor. Mr. Schovanec, are you the same Erik Schovanec who caused to be filed in this proceeding pre-filed direct testimony, petition staff report testimony, rebuttal testimony, and 3 exhibits thereto?
I am.
If I asked you those same questions here today, would your answers be substantially the same?
Yes.
Do you have any corrections or modifications to make to that testimony and exhibits?
I do not.
Your Honor, I would move for the admission of Mr. Schovanec's direct testimony, petition staff report testimony, rebuttal testimony, and the 3 exhibits to that rebuttal testimony.
Are there objections? Okay.
But I will just object to foundation and hearsay to the exhibits.
Okay, thank you. The exhibits will be admitted. Proceed.
In that event, Your Honor, I'll tender the witness for cross.
Thank you. I'm not sure if your placards are already up, so Mr. Long, go ahead.
Mr. Schovanec, good afternoon. I'm John Long, an attorney with the Office of Consumer Advocate. Will you be responsible for setting company policies and giving instruction to construction crews regarding stoppage in wet conditions?
I will.
Is it your understanding that the inspector, the county inspector appointed by the counties, has sole authority to halt construction if he or she determines that the wet conditions that are present?
I think the board rules, give some guidance around, what defines wet conditions. It's not entirely prescriptive. My expectation would be that, we would consult with the county inspectors ahead of construction, have coordination meetings, and clearly define and understand what constitutes wet conditions. I know that we've got recommendations on what that may look like based on consultations with our, certified professional soil scientists and, other inspectors that have performed this work on projects in Iowa previously. So I guess I would say that I don't believe that the county inspectors have sole authority there, that it's more of a collaborative effort in following the board rules and the AIMP.
So is it your understanding, based on the board rules, that the county inspector will be on site for construction and restoration?
Yes.
If there's a disagreement with the county inspector saying construction should halt and the company's construction crew saying it should not, who would have sort of the last word and authority based on your view of the board's rules?
Again, I think that, we would, hope to hash out those terms before construction starts so that everyone clearly understands when we will or won't work. I know that, our soil scientist has made recommendations on what constitutes wet weather based on, percentage of standing water on the right of way and things of that nature. And those are, pretty prescriptive to be able to define. Again, it's just getting agreement on that with the board and with the county inspectors ahead of construction starting.
Will you instruct your crews that despite all those efforts to reach a consensus beforehand, that in the moment, if the county inspector says construction needs to halt, will you instruct your crews to follow that instruction?
Again, if the agreed upon criteria is, results in us needing to shut down the work, then we will certainly make sure that our contractors are not working in what's been established as wet conditions.
You no more questions, Mr. Long?
No more questions.
Okay, there, it's working now. Okay, Mr. Whippel?
Thank you, Your Honor. Mr. Schovanec, we've met. My name is Tim Whippel. I represent 7 counties in this proceeding. I want to ask a little bit more, a few more questions along the same lines that Mr. Long asked you about wet conditions and county inspectors. To start, you've reviewed the testimony of county's witness, Kruzinga.
I have.
And you're aware, aren't you, that as a county inspector, Mr. Kruzinga would prefer more clarity on wet conditions?
Yes, I'm aware of that.
And you're aware that Mr. Kruzinga doesn't feel that under the current rules, there's enough authority provided to county inspectors to halt construction?
My understanding that is his opinion, yes.
And he's the county inspector, right?
He is, I believe, representing ISG as who is representing a number of different counties. So he will be representing, I believe, managing some of the individual county inspectors for certain counties.
Wouldn't you agree it would be good to have really clear rules on when construction could stop?
I mean, I believe that it'd be good to have, established criteria. I don't think, necessarily that's, black and white all the time. I believe that, if the topsoil is stripped, that the opportunity for, mixing of the topsoil and the subsoil is, that risk has been eliminated. And having wet conditions will not, further cause, further detriment to the soil at that point. It does introduce, different other items such as compaction and other things if it's really wet. But, trying to have a hard, fast rule tied to how far pieces of equipment sink in or how much, water there is on a property, I think that's really hard to determine. Certainly if there was a way that could be reached and we all agreed on that, then more than willing to, do whatever the board wishes us to do on that front.
So you're getting ahead of me a little bit. I just want to know from the get-go whether you agree clear rules would be good.
I believe the rules that are set in place now that the board's adopted are sufficient to manage the construction of the project.
So I'll take that as yes, clear rules would be good.
The existing rules, I believe, are sufficient.
County's witness Kruzinga disagrees about whether the current rules are sufficient, but he also prefers clear rules. Do you agree objective criteria would be good?
I think I'd have to defer to one of our other witnesses, Aaron DeJoya, who is a certified soil scientist. He's going to be able to, answer those questions about if there is a means to objectively define what wet conditions are. My understanding is that the existing rules are sufficient. They've been, beefed up per se since, Dakota Access and other projects. And that, they should be, good for us to construct our pipeline.
But it's you and it's Mr. Kruzinga who have to make this work in the field, right? And have to be able to agree on when the rules that have been developed by people like Mr. DeJoya or Mr. Liedman or the board apply. And because it's you guys who have to decide when construction stops, right?
That's correct.
So wouldn't it reduce the number of disagreements over whether construction should stop to have objective criteria?
Potentially.
Thank you. I want to move on to some other topics then, and mostly related to your rebuttal testimony and those exhibits. So if we could pull up his rebuttal testimony, I'm going to refer in a few places to that. So at page 7, line 15 of your rebuttal testimony, you accuse Professor Hamilton of misunderstanding how pipelines impact present and future land uses. And at page 7, line 23, you accused Professor Hamilton of wrongly stating that pipelines prevent other uses. But isn't Hamilton's point that it's the zoning regulations that restrict the uses?
You know, I'm not an attorney. You know, the point I was trying to make is that, you know, pipelines coexist with development all across the U.S., including Iowa. I'm sure you've heard the statistics that, you know, there's 47,000 miles of pipe, there's 13,000 miles of PHMSA-regulated pipelines in Iowa. You know, we've done an analysis. There's tens of thousands of, you know, dwellings, businesses, churches within near vicinity of those pipelines. And in our estimation, they have not curbed development. They can coexist with almost all land uses.
Right. So I'm going to stop you there because that's really not what I asked.
Okay.
All right. So you've read Hamilton's testimony, yes?
Yes.
You say you've reviewed zoning regulations, yes?
Yes. I haven't reviewed every single word of every zoning regulation that's been proposed, but yes, I have.
Well, that'd be quite a job. I haven't done that either. But,
yeah.
But generally speaking, the company represents that it has reviewed zoning ordinances for the counties that are in your footprint, right?
Yes.
Okay. So you make statements in your rebuttal testimony about Hamilton's testimony. And so I'm not asking for your legal opinion. I'm going to explore with you what you've said about Hamilton's testimony.
Okay.
Okay. So isn't it a mischaracterization of Hamilton's testimony to say that he thinks a pipeline prevents farming afterwards?
Can you rephrase that?
Let me rephrase that. Hamilton's testimony talks about how zoning regulations prevent certain types of uses within certain zones, doesn't it?
I'd say that's correct.
So, is there anywhere in Hamilton's testimony where he says constructing a pipeline would prevent farming afterwards?
I don't recall if he specifically stated that, but, you know, I guess, again, my point is that, you know, I'm not refuting everything that he mentioned. You know, in my estimation, and again, I'm not an attorney, counties have the authority to regulate certain things, and they have the authority to not regulate certain things, and the placement of a pipeline, to me, is not in the purview of a county.
For the moment, I'm just asking about what's in Hamilton's testimony, since you've reviewed it and you're talking about it in yours. You know, I would represent that it doesn't say pipelines prevent farming. Isn't it more accurate to say that a zoning regulation would prevent farming in a zone that's of another type?
Zoning regulation would prevent farming in a zone of another type.
If an area is zoned residential,
Yep.
can you put a factory in there?
Objection, Your Honor.
State your objection.
Calls for a legal conclusion as to what the zoning ordinance allows.
Mr. Whippel, do you have a response?
Your Honor, he said he's reviewed zoning ordinances. He has testimony about lawsuits. He's talking about what zoning ordinances do and do not require. It's all over his testimony.
Okay. You may answer if you know.
You know, again, if a specific county zoning ordinance precludes certain, you know, land uses within a county, and like you said, an area is zoned for agricultural and it doesn't allow for residential development, then I would agree that that would not be allowed in that county. That's what the zoning ordinance says.
And that's to say that it's the zoning regulation and its content that prevents it, right?
Again, I'm not an attorney, but I would say yes.
I want to move on to another part of the testimony. Isn't it true that the terms of Summit's easement prevent a landowner from building structures within the 50-foot easement area?
That's correct.
And that would include housing, right?
In the permanent easement, correct?
In the permitted easement. And you
Yes.
can't put a factory on the permitted easement either, can you?
You cannot.
You can't put any structure in the permitted easement, correct?
You cannot put any permanent structure within the 50-foot permanent easement.
So at page 8, line 8 of your testimony, you say Hamilton's making false statements about the easement corridor. But aren't you misconstruing his testimony? He's talking about the 50-foot easement corridor, isn't he?
You know, I took his testimony as he's saying that you cannot develop, there won't be developments happening around pipelines. So in my estimation, you cannot build within the 50-foot permanent easement. However, you can develop the full extent of the rest of the property. And, that's obviously seen thousands of locations across the United States where there's, neighborhoods developing all around pipelines.
So maybe you just misunderstood Hamilton's testimony instead of Hamilton making a false statement about the easement. Wouldn't you agree?
If he was intending to say that the easement stating that you cannot develop, a neighborhood or an industrial complex within the 50-foot, then yes.
Okay. I want to move on to the proximity study, which was your rebuttal exhibit 2. There we go. You didn't prepare this study, did you?
I did not.
Who prepared this study?
So my understanding is that this was prepared for Dakota Access when their project was developed.
Yeah, but who prepared it? Let's go one question at a time.
I can't recall the name of the company that prepared it.
So you wouldn't know the person either.
It's escaping me at this point.
Do you know the background of the person or firm that prepared it?
I don't know all the details of the person that prepared it. I think essentially the point of the exhibit is to show in multiple locations across Iowa that there was a pipeline installed with no development in the near vicinity of that across agricultural lands. And over time, there were developments that were built all around those pipelines. And that was generally the intent of providing this exhibit.
Are you a real estate agent?
I am not.
Are you a real estate appraiser?
I am not.
Are you qualified to evaluate the analysis of people who are?
In what capacity?
Well, let's assume whoever prepared this study was a real estate appraisal firm. That seems likely. Wouldn't you agree?
Not necessarily.
Well, it's your exhibit. Who made it? What's their background?
Again, the intent of the exhibit is to show that there's been significant development around existing pipelines in Iowa. This is pointing to 3 specific examples. I don't think you need to be a real estate professional to show the intent or to understand the intent of what this was for.
I'd really like to get into the accuracy and the relevancy of this study. And I think that begins with understanding who made it and what the assumptions are. Wouldn't you agree?
I would say that, trying to debate the accuracy of a pipeline and basically pictures over time showing housing being constructed around those pipelines, I'm not sure what there is to debate about the accuracy of that.
So this was prepared for Dakota Access, right?
That is my understanding, yes.
Dakota Access is an oil pipeline, correct?
Correct.
When was this study prepared then?
Again, I don't have the exact date. It would have to have been in, 2007, 2006 timeframe, I would imagine. Shortly before Dakota Access was installed and commissioned.
So that's quite a while ago.
Correct.
So would you say it's stale?
I would not.
You wouldn't.
I would say that, you know, the intent and the showing of what this was for is not stale. I mean, there's pipelines and development around pipelines happening every day. This was just to pinpoint a few, you know, discrete examples of that.
Yeah, but this is a study about value. Right?
You know, for the purposes of myself, you know, it was to show that the development can happen around the pipelines. You know, the development, I mean, the pricing and how that impacts pipelines. You know, Mike Rory, our director of right-of-way, would be much more equipped to speak to that portion of it.
But you're sponsoring the exhibit. So I'm going to ask you those questions.
Okay.
All right. If development happens around pipelines, wouldn't that be because zoning authorities allow it to happen?
Objection, Your Honor. Calls for legal conclusion as to what zoning ordinance allows.
Your Honor, he's already testified and responded to a number of questions about what zoning allows, and he's the one introducing the study and the maps.
Okay. You may answer
Again, I'm not a zoning expert. If an area was zoned for, you know, development and residential use and a pipeline was placed across that property, then I would imagine that, you know, unless that property was rezoned, that they would have the authority to construct around the easement.
But I'm not trying to trip you up with tricky legal questions. I mean, just generally speaking, when someone wants to build a home or a new commercial building, they have to get a zoning permit, right? I mean, it's kind of common knowledge, isn't it?
I would imagine that, yes, they would need a permit to construct.
So just logically, that would have been approved by zoning authorities.
What, the construction of a residential dwelling within the vicinity of a pipeline, or what's the question here?
Yeah, correct. The construction of a residential building in the vicinity of a pipeline, after the pipeline's installed, presumably it's still subject to zoning, correct?
Which would be considered independently of the pipeline easement.
Does this proximity case study anywhere address zoning regulations?
I don't believe so.
Okay, I think we're done with the proximity study. At page 7 of your rebuttal testimony, you refer to a lawsuit between Shelby County and Summit. Are you aware that that lawsuit's been appealed to the 8th Circuit and that the result is not final?
I'm aware that it has been appealed.
Are you also aware there are 5 other lawsuits pending over zoning?
I wasn't aware of the exact number. I knew that there were several others that were pending.
So you would agree, wouldn't you, that there's not a final answer on preemption?
I'm not an attorney, but I know that Judge Rose ruled that, you know, what Shelby enacted was superseded by both federal and, you know, state regulations. You know, how the appeals work out and how that is affected by other, you know, pending legal action, I can't comment to that.
But it could take some time, wouldn't you agree?
Again, I'm not an attorney.
That's all I have, Your Honor.
Thank you. Mr. Meyer?
Thank you, Your Honor.
Mr. Meyer, you can move that mic around. You don't have to lean over so far, unless you want to.
So I represent Hardin County Supervisors. Do you have any experience with pipeline construction under private farm drainage tile?
I do.
When?
So I was involved with a ethane pipeline constructed in Ohio for Kinder Morgan.
I'm sorry, what kind of pipeline?
It was ethane.
What is that?
hazardous liquid pipeline ethane, which is a constituent of natural gas liquids.
As far as the size of the
12-inch
pipe
diameter.
and the pressure, is it similar to what is proposed in this permit application?
I would say yes, it is.
How long ago was that?
I think it was 2016.
That was in a different state?
It was in Ohio. There was extensive drain tile across the entire footprint of that project.
Do you have any experience with private farm drainage tile in Iowa?
I do not.
Have you become familiar, or have you familiarized yourself with the drainage districts to be crossed in Hardin County?
Generally, I am familiar. Obviously, we've got a team of people working for us, and we've got others on our team that have been handling the drainage district relationships. So generally, I'm familiar. All the specific meetings that have happened. I believe dozens, if not hundreds, of meetings have been conducted with the drainage districts, and there's other representatives at our company that have been conducting those.
When you say generally, does that include sort of the general idea of how private drainage tile districts are governed and how the costs are shared between growers within that district?
I'm not aware of those specifics.
Have you become familiarized with the Hardin County Drainage District permit requirements in the districts that you're going to traverse?
I'm aware generally of some of the requirements that they've requested. I think that we cross, I believe, almost 200 drainage districts and in 17 counties. So there's quite a few, different counties involved here, and I don't know the specifics of every single county and every drainage district.
And to make sure we're talking the same language, when you say drainage districts, you mean formally organized under Chapter 468 of the Iowa Code?
I believe that's correct, yes.
Okay. Have you reviewed the direct testimony of Hardin County witness Lee Galantine?
Yes.
And did you review the exhibit, in particular the exhibit that set forth the permit requirements to go through private drainage tile districts in Hardin County?
Again, I've reviewed it. I don't recall all the specifics. I do recall some of the, criteria in there that would be, difficult to comply with or, problematic for us per se.
And difficult could just be another word for challenge, but it could be completed yet comply with the permit requirements as they exist currently in Hardin County, right? I'm not saying it's your preference, just that it could be completed and still comply.
There's certain, items within, I believe that, county's drainage district ordinance, as well as others that, in our estimation, could be, more detrimental for counties, and or just, items that we don't think add any value, but add, burden and cost as well, such as the GPS tracking on all the equipment that's 8,000 pounds and higher.
Have you ever sat in on a drainage district meeting where growers dispute who caused a drainage problem in their district, and how are those costs going to be shifted among themselves?
I have not.
GPS would help a lot with those arguments. That's why that's required. But are you saying today that Summit couldn't comply? This project would die if you had to comply with those drainage district permits?
No, what I'm saying is that there are certain things within that ordinance that I think are unduly burdensome with adding no value. Again, the 8,000 pound limit, GPS tracking. And again, I'm not a farmer, but I would venture to guess that basically every single piece of farming equipment exceeds that. I doubt that any of the farmers on the properties that we cross are going to have GPS coordinate or tracking devices on their farming equipment. So I don't know how that would automatically, identify who had caused any kind of, drainage issues.
Well, in the future, when a problem arises, knowing who crossed, what it weighed, and where it went is going to resolve or go a great distance in resolving disputes as to who's going to write the check to fix the broken tile. Would you agree that that information would help resolve those disputes quickly and efficiently and fairly?
I don't believe that putting the GPS trackers on equipment 8,000 pounds is higher is going to cause that to be easily resolved. And again, for the reason I just mentioned, that every single piece of farming equipment exceeds 8,000 pounds. So there will be a dispute as to whether that was, the farmer themselves that caused damage. But the intent of Summit is to resolve all issues. And I know that in our easement, and again, I've worked in states that have drain tile. I've worked on projects that have drain tile, and pretty typically it's a 1-year warranty on the drain tile, and then it's the farmer's issue after that. In our easement, we've put that we're going to warranty drain tile indefinitely. So if there's an issue in year 2, year 5, year 10, year 20, we're going to be obligated to come back and fix it and make it right. Certainly, we would extend that to the counties and the drainage districts as well. And so, being able to identify what caused the problem and being able to come back and rectify that, we certainly are, willing and wanting to be able to do that. I just don't think that the 8,000-pound GPS trackers are the way of doing that.
So I know you don't like that aspect of the permit, but this project could move forward even if it had to comply with every letter of the existing permits, correct?
I mean, I would say again that there are certain things in there that we don't believe that should be part of that. We'd like to try to talk through that and come up with a different solution. And I'll just leave it at that.
Well, can you let your yes be yes and your no be no? You could do this and still comply, correct?
Could we put GPS trackers on every piece of equipment if we absolutely had to? Yes.
Thank you. Other questions?
Thank you. Mr. Jorde, I believe you're next.
Thank you. Is it true you did not use any plume or dispersion modeling when laying out the preliminary pipeline route?
That's correct. Jimmy Powell obviously discussed that ad nauseum yesterday. The plume model, the dispersion analysis, is not a routing tool. It's used to inform risk. So again, that was pretty well established yesterday with Mr. Powell.
And that's the opinion of industry, who says, forget the fact that this may not be an intelligent route. We'll just focus on ways to minimize or mitigate that risk, right?
I disagree with that.
So you would agree it would be intelligent if we are analyzing if a route should be approved to first know and appreciate and understand the risks relative to CO2 air dispersion and plume modeling, correct?
I disagree.
Do you believe that citizens and first responders in counties and people with responsibility for existing assets, existing land use, homes, businesses, would be better informed if they were aware of the actual risks via sharing a dispersion model or plume model?
Not necessarily. Again, the dispersion modeling, the analysis, all the discussion around that. We've got other witnesses such as, Brian Luke and others that are going to be able to speak to that much more intelligently than me.
Now, 24-inch pipeline, are you aware of larger CO2 pipelines under the pressure you propose than 24 inches anywhere in the U.S.?
I'm aware that there are pipelines in service today, CO2 pipelines that are operating at pressures north of 3,000 psi, and there's also 30-inch diameter CO2 pipelines. So there are pipelines currently operating safely today that are larger diameter and operating at higher pressures.
And for you to use the word safely, is that because there hasn't been some catastrophe yet with those pipelines?
I use the word safely because, there's around 5,400 miles of CO2 pipelines in service today across the U.S. in a handful of different states. We've done an analysis on those pipelines just to put it into perspective. In the near vicinity of those existing pipelines, there's tens of thousands of structures currently operating safely. I've analyzed the routes of those pipelines. I've identified schools that are within 50 feet of existing CO2 pipelines. I've seen churches and businesses and schools operating in the near vicinity of those pipelines. And the PHMSA regulated pipelines that have, public safety records. So the safety record for CO2 pipelines is pristine, essentially comparable to other infrastructure, certainly comparable to railroads and other, infrastructure. So CO2 pipelines in the last 25 years have only had one PHMSA recordable injury. And that was as a result of a pipeline contractor striking a CO2 pipeline during clearing activities. So no one has ever died from a CO2 pipeline, and that's why I believe that I can say that CO2 pipelines are safe.
And I'm so glad you brought up injury. You understand that it's the operator's responsibility to report injury, to self-report. PHMSA doesn't send out people looking for injuries. Do you understand that?
Well, a prudent operator is required to follow PHMSA guidelines, and if there's a lost time injury, then they would have to report that to PHMSA to be in compliance, and then that would be part of the record.
So you'd agree with me that it's incumbent upon the operator to decide if they report something which they determine is an injury or not report it, correct?
So I would agree that if a negligent operator fails to make prudent, reporting requirements, then yes, that they would be breaking the law in my estimation.
And is the gist of your pitch here, sir, that because other people have made unintelligent decisions of putting schools nearby, potentially fatal pipelines that could injure and kill the people involved in the activities on the playground or in the school, that therefore this board should just go ahead and give you the route you want in Iowa?
No, that was not the intent of my comment.
Okay, so who cares if somewhere else there happens to be a pipeline and there happens to be a structure? That's not at all relevant to this project proposed by you in this state. Would you agree?
I would say that, the existence of CO2 pipelines across the United States is certainly relevant to what we're doing here today. And the, safe coexistence of those pipelines is certainly relevant to what we're proposing here today.
Okay, and you're referencing other projects that are not owned, operated, or managed by Summit, correct?
Other projects that were built to the same design, construction, and operation standards that we're going to comply with.
Okay,
and exceed.
So you're complying with the same construction standards as the 20, 30, and 40-year-old pipelines. Is that what you're saying?
We're complying with PHMSA guidelines, which those pipelines did as well. And we're exceeding those guidelines in a number of different ways.
You say that the preliminary route was determined. It's an iterative process, requires input from many experts. Were there any experts you consulted that you didn't also pay?
Not that I recall.
And you use a curious word there, stakeholders. Are the people on the potential route, the communities, the boards of supervisors, county boards, are those kind of people considered stakeholders that would be important to hear from in determining a route?
Certainly that I believe that I consider all landowners, other constituents, stakeholders informing the route. But the preliminary route, you don't go out and talk to 6,000 landowners. What you do is we establish the preliminary route. We did a detailed analysis with routing experts, subject matter experts across environmental, cultural expertise, constructability, existing land uses, trying to follow existing infrastructure where possible, and then once the preliminary route is established and the corridor has been established in Iowa, then that's when the detailed analysis on the route takes place, and we engage with all landowners across the entire project footprint. We conduct our surveys. We see where we can or should place the pipeline. We consult with landowners, and we've adjusted the route 1,500 times in the state of Iowa, and hundreds of those route adjustments were made at the request of landowners to accommodate their existing and future land uses.
All right, so it's true you didn't consider any future land use maps or master plans prior to getting the preliminary route set?
That's not correct. So our GIS company did pull down information from the Iowa Economic Development Authority and overlaid that with our pipeline route, and found that there was no obvious conflicts outside of existing wind farm and solar farm developments, which we certainly knew we would cross, and we would work that out with those entities. So I would say that is incorrect.
So do you have firsthand knowledge, and can you tell me the name by county of each county whose master plan for the county development was utilized in informing the preliminary route?
I cannot give you that specific information.
What about a single city?
A single city that what?
Where you utilize the future land use or the master plan or the vision plan, whatever that city might have called it, to help inform Summit when selecting the initial route?
So again, once the initial route was developed, we did outreach to counties. We've had thousands of meetings, emails, correspondence with county engineers, county officials. I believe we've had over 300 in-person supervisor meetings, and we did take into consideration hard concrete development plans, but quite frankly, there was on a hand how many you could actually count that were provided to us. I can name a specific example around Merrill and Plymouth County, where the county engineer, the county supervisors had advised that we move the line further west to get around an existing development. We did move that route to accommodate the request and to accommodate the landowner, and all landowners within the near vicinity all around the city of Merrill signed voluntary easements. So that is one of the only concrete things that was identified to us, and we did adjust the route to accommodate it.
You would agree there's no such thing as a voluntary easement with the threat of eminent domain over someone's head, correct?
So I disagree with that.
Okay, will you commit today on behalf of Summit to not use eminent domain to acquire any parcels or any easements that you desire for your proposed project?
I can't make that commitment.
Okay. And in terms of rerouting, would you agree that if you move by 1 foot from the route you had to a present route to accommodate one small thing on a landowner's piece of property, that you would be including that in your 1,500 reroute number?
I don't know about 1 foot. I know that there's some of those that were minor reroutes, some were more major reroutes. Certainly the pipeline has moved considerably on individual landowners' properties. We've hugged property lines. We've completely adjusted the route on their property to accommodate their needs and concerns. And I think that reflects why we're well over 70% acquired on easements.
What's the difference between a minor route and a major reroute?
I think that's subjective, but to me, shifting the pipeline tens of feet to accommodate, survey findings, cultural sites, wetlands, things of that nature would be more minor. A landowner requesting that we completely alter the alignment of the pipeline to HUD property lines, to me, would be more of a major reroute.
So there's not a number where we shift from minor to major in terms of how Summit looks at this? Number of feet?
No, not that I'm aware of.
Okay. How many right angles does the proposed current route have?
I don't have that figure in front of me or know that number.
You would agree that it has many 90, 60, 30 degree curves and angles in it as it meanders across Iowa, correct?
That's correct.
And it would be true then that you could, if you were granted a permit, run along the property line of any landowner's property rather than going, for instance, directly through the middle or from corner to corner dissecting the field.
So a couple things there. One, I would argue that the impacts of that property would be more substantial if you're adding significantly more pipe on that landowner's property, and encumbering more of that land. Secondly, with well over 70% acquired for the state of Iowa, the point of entry and the point of exit could very well be established on the landowner's property. So, there's constraints there. And then even further with the Iowa process and the Exhibit H process, we have a certified plat identifying the exact location of the pipeline alignment on that landowner's property. So at this point, I'm not aware that we can make those wholesale changes. If it leads to a voluntary easement now, it leads to an easement being signed before condemnation proceedings move forward, then I believe we can make those changes, and we have, and we continue to try to work with landowners on the route. But a wholesale, we're going to HUD, property lines is not possible at this point.
Well, it's possible. You just wouldn't want to do it.
I don't believe it's possible based on the Exhibit H process.
You don't think you can change that? Well, then what's the point of the value of the statement saying we're willing to work with landowners and just talk to us, gosh darn it, and we'll work with you? If you can't move it, then what's the point in talking to landowners and hearing them out?
I think we still can move it, and in minor adjustments at this point, we're still willing to listen to accommodate those if we can. The route is very mature. We've completed 97%. I think almost higher than that percentage of our surveys, cultural surveys, bio surveys, all those types of things. We have, Army Corps of Engineer permits. We have all of these other additional permits that are applied for and in process. So, again, minor shifts to the route to accommodate landowner needs. We're still willing to do that. Completely altering the alignment and hugging all property lines across the state is not something that we can do at this point.
Well, again, you could do it. I mean, are you telling me if this commission or this board put a condition on it to do just that, you'd say no and you'd leave and you'd say no more pipeline?
We're going to do whatever the board asked us to do.
Okay.
Adding additional pipe. So if you bisect a property versus hugging the property line, you're adding significantly more pipe. So you're encumbering more land. You're causing more disturbance to the soil. There's a lot of reasons why what you suggested to me is not the most favorable thing.
And because your premise is encumbering more than you have to is not a good thing.
Generally, yes.
Okay, so encumbering any is then also a bad thing.
I disagree. I mean, we need to build the pipeline. We need an easement to construct it. We need a permanent easement to build the pipeline.
Well, there's been no showing that you need anything, and there's been no showing that anyone on earth needs this pipeline. You have a preference to capture tax credits, and that's what you want. You don't need anything, do you?
Objection, argumentative.
Do you have a response?
No, I don't think it's argumentative. That's my response.
Okay, I think you can rephrase your question.
Okay, you don't need anything. You want a pipeline. You want the ability to make money, and that's fine, but you don't need it, do you?
So we're endeavoring to build this pipeline for all the economic reasons that Mr. Paroli and Mr. Powell and Mr. Broghammer, gave us. I'm here to construct design, construct, and commission this pipeline. So I'm not here to debate the need of the project.
All right, good. So you agree then you don't need it, right?
I disagree.
Okay, why do you need this pipeline? Why do you need it? Not want it, need it. I mean, maybe you'll convince me and I can go home. So give me your best shot.
Again, it's the need for the project has been portrayed by others that have already gone and testified. And I'll leave it at that.
Okay. How many letters from tribes supporting your project do you have that you've submitted in this docket as evidence? Native American tribes.
I don't recall that information. We have a very robust tribal engagement plan. We have others, that are part of the project that are much better equipped to speak to that. I know that we've, tried to go above and beyond where we can to, work with tribes to, use tribally owned businesses. We're using some for our fabrication of some of our equipment. We've made the commitment to conduct tribal surveys for the entire pipeline route, and that's completely voluntary. That's not required. So we're doing everything we can to engage the tribes and to keep them part of the process. But there's another witness, Mr. John Schmidt, that would be better equipped to speak to details there.
You say, when asked the question, are any homes displaced along the project route, you answer no, and displaced would mean a home that is within the 50-foot desired permanent right-of-way that would have to be moved. Is that correct?
That's correct.
All right. And do you have a list? Have you uploaded a list where it shows how many feet the proposed center line of your proposed pipeline is from any existing residence?
Have we uploaded a document that shows the location of our pipeline and the distance to every single residence along the entire pipeline route? I don't believe that's correct.
All right. Well, and I don't think you have either, but wouldn't that be good to know in judging whether or not this is an intelligent route that you've selected to see how close you are to existing residences?
I know that some of the data requests, requested generally are specific, quantities of dwellings within certain setbacks, and that's been provided. If, additional information is requested by the board, certainly we'd be willing to comply with that.
Okay. What about the landowners that you want to work with? I'm asking you on their behalf if you can produce that. Would you do that?
If the board asked us to produce a document, every landowner that's got the pipeline routed on their property should certainly know where the pipeline is in relation to their home. And if there's specifics, we can provide that as needed.
Is it true that the surveys or the quasi-surveys that you've attached to easement proposals, that they say essentially that those are preliminary and leaving wiggle room for movement of the potential pipeline on an individual property?
I guess I'm confused by what's a quasi-survey. Are you referring to the sketches that were attached to the easement?
Sure.
I'd have to defer to Mike Rory, who's our right-of-way expert on details of the easement and what legally we think we can or can't do in relation to moving the pipe.
You talk about a temporary reduction in crop yield. Where does temporary stop and where does permanent start in your mind? How many years?
I think there's a lot of different factors involved with, how quickly the yields will come back. Certainly weather's a big part of that, and what compaction. I think that, the board rules have been expanded to try to mitigate that as much as possible. And, certainly we're going to do everything we can to make sure that we do our reclamation correctly and have yields come back. With that said, I believe, and again, Mr. Rory can speak to the details, but I believe we've made a commitment to keep landowners whole for crop deficiencies indefinitely. And that if those can be proven even after year 4, year 3, year 4, year 5, that we would keep landowners whole.
And the could be proven, that's the whole key, right? Basically, the landowner who is potentially having this project forced upon them has the great privilege of having to convince you or your counterpart after you've sold and are gone that in fact the construction was the proximate direct cause of the future or experienced crop yield loss, correct?
It'll be very clear through an as-built that's provided where we constructed the pipeline. I certainly would not think that we're going to dispute landowners' claims of any crop deficiencies in the area of the easement that we've constructed in.
But unless you remove that requirement, the hurdle for the landowner to go out and get the yield maps and get whatever data they have and get their crop records and then find somebody somewhere when they call an 800 number to present it, and then you can just say, no, it's on the landowner to prove to you that there was yield loss caused by you, right?
There's got to be a mechanism in place, and I don't know if that's been established, and I certainly am not the one involved with that to be able to prove that up. I would imagine we would make that as, least burdensome as possible. And, in my experience working at pipeline companies, the benefit of the doubt typically, from what I've seen, the landowners, would be kept whole on something, even if there's some subjectivity involved there. And I know with the management team that we have in place that they want to do right by the landowners. So again, I believe and I feel strongly that they're going to do right, and they're going to, give the benefit of the doubt to the landowner when it comes to things such as, crop yield deficiencies, drain tile issues, etc.
If you want to do right by landowners, why are you suing over 120 families for eminent domain in South Dakota before there's even a permit application granted to you?
Again, you have to speak to Mr. Rory about the eminent domain and right-of-way concerns.
Okay, what about the lawsuit suing landowners for surveys that you then just dismissed, said you didn't need them after all? What about that? Is that doing right by landowners?
I think there was a couple within the state of Iowa that happened, and again, I'm not an attorney. I can't speak to the legal reasons that was completed. We've surveyed north of 97% of the entire route of Iowa, and the purpose of the surveys is to inform the route so that we can have a constructible, route that, does not cross, critical habitats, does not cross, culturally sensitive sites, et cetera, et cetera. So those surveys are critical and needed for all of our permits, including those with the Army Corps of Engineers. So it's not something that we're doing on a whim. They are needed to actually build the pipeline.
All right. I will offer exhibit LO 555, which is this witness's deposition.
No objection.
Seeing no objections, it will be admitted.
Thank you. You're familiar with the overall route map that can be found on Summit's website under the project footprint links for Iowa. Is that fair?
I can't say that I've gone and looked at that map recently. I don't know what version of the route that's projecting at this point.
Okay. If we could please pull up landowner 557, please. And in the meantime, while we're doing that, you were talking about equipment and 8,000 pounds and heavy equipment. Do you know what, at a 4-foot depth, your pipeline is rated at? How much weight can be driven across the easement if at 4 foot of cover and not adversely affect the pipeline?
I know that, our engineering company has done load analysis on the equipment that would cross the pipeline. I don't have that readily available off the top of my head on what the maximum equipment weight is that could cross the pipeline at that depth, but I would imagine it would be very significant and much larger than any equipment that would be used for normal for farming operations or abnormal operations.
Okay, so who would actually know that answer?
I mean, I could find out.
Well, I need to know now. So if you don't,
Specific engineering details I don't have off the top of my head. So if that's something that's needed, we can get the analysis and upload something to the docket that shows that. But I don't have that off the top of my head.
all right, and you don't know of any witness scheduled to testify after you that would know that from your side?
I can't imagine that anyone's going to know those exact figures off the top of their head, and certainly none of the other witnesses that I'm aware of would know that information.
It's true as of right now, you don't have any permit approvals in any state to locate your proposed hazardous pipeline, right?
That's incorrect.
So you have statewide permits, approvals for routing and siting?
We do not have any statewide permits.
Okay.
You asked if we have any permit approvals, and we do.
Well, not for routing. You've got water approvals. You're going to suck out a bunch of water everywhere. If you get the route, I get that. But you don't have any siting or routing approvals, right?
That's incorrect.
You think you have siting and routing approval?
I mean, we've got approved permits from railroads and counties that are, approving the installation of a pipe at a certain location. So to me, that informs the route. That's a routing permit. But
well, it doesn't inform the route because you said, here's our route, and then you wanted to get a permit that corresponds with the route you have. So it's not informing the route. You based it off your route.
yeah, so we have permits permitting the existing placement of our route.
Okay, which none of that can happen until each state actually signs off on it, correct?
Correct.
Okay. Now, looking at the map, Exhibit LO557, and this was taken directly off your website, so to the extent this is incorrect, you might want to change your website. But you see on the left-hand side there, when in Iowa County, you've got a facility there, apparently someone that's signed up with you, and then going all the way south down into Fremont. Fremont County, I asked Mr. Powell about this. He kind of name-checked you, that you were the guy. Do you happen to know how many miles that is from that yellow star in Ida County to the yellow star in Fremont County?
I think it's order of magnitude 120 miles or so.
And so you would agree then that it makes no sense for this board to approve a route traveling 120 miles across multiple counties affecting hundreds of landowners solely for the benefit of that Fremont located ethanol plant, right?
I would not agree with that.
Okay. And so do you believe that this board engages in a weighing of positive and negatives such that the sole Fremont ethanol plant justifies 120 miles of additional hazardous pipeline in this state?
I think there's criteria that the board uses to analyze granting a permit for a pipeline project, and certainly this pipeline line segment would be considered in that. I believe Mr. Powell testified yesterday that there are additional ethanol plants in the vicinity of this pipeline who we are certainly talking to, and would be hopeful to add additional ethanol plants or other emitters, which would tie in to this line segment. And I would add that the line segment that you mentioned were well over 70% acquired on that. I believe that it's almost 75-80%. So I think that there's been a lot of supportive landowners on this route that have signed easements and come to terms.
Okay, so I guess your answer is then no. You think it's justifiable for a single private business, the Fremont ethanol plant, to impact 120 miles of easements for its sole benefit?
My answer is that I believe that yes, it should be a part of this project, and there's not some set mileage criteria that determines whether some plant could or couldn't be a part of this project.
Well, sure, but you wouldn't expect this board to give you a permit based on your hopefulness, would you, of future potential plants joining?
You know, what we're asking the board for this pipeline line segment is to connect to an existing plant that's part of the project. It's not hopeful that others would sign up. There is a plant that's already part of this project.
Right, okay. And you stand by all the answers you provided in your deposition, which were given under oath, right?
Correct.
All right, thank you. I don't have anything further.
Thank you. Mr. Taylor, you are up next. We plan to take a quick break at 3:30 and then come back at 3:45 to go into confidential session. So just want to put it on your radar so you can adjust questions if necessary, unless you think you'll be done in that time period. So just want to put it on your radar.
I'm pretty sure I'll be done. I don't have that many questions. I don't think. Mr. Schovanec, in your prepared testimony, you said that one of your fields of responsibility is to determine the environmental impacts along the route. Is that correct?
I'm sorry, I didn't quite catch that. Can
Sure. From your prepared testimony, I gathered that one of your responsibilities is determining the environmental impacts along the route.
Again, you know, we've got a team of personnel and we have others that are specifically responsible for the environmental and cultural impacts to the project. And certainly I'm aware of that and overseeing that in some capacity.
So you oversee that?
Generally, yes.
Okay. If we could look at page 6, line 19 of your initial testimony, your direct testimony. You talk about environmental reports. What did you mean? Describe the environmental reports that you're mentioning there.
You know, to me, environmental reports are, you know, we've conducted field surveys. Certainly there's data collected from that for, you know, cultural surveys, the tribal surveys, biological surveys, species habitats, et cetera, et cetera. The environmental reports to me are, you know, the reports that are generated after compiling all that information and, you know, submitting those reports into either the state process or with the Army Corps of Engineers, U.S. Fish and Wildlife, Department of Natural Resources, et cetera. So to me, it's just all the various reports that are compiled for the different permitting needs across the project.
And so there are written reports from the environmental surveys and investigations that were conducted, correct?
Again, there's specific reports and that are filed applications for certain permits. So Army Corps of Engineers, for example, I know that, you know, there were reports conducted, compiled for, you know, SHPOs, again, DNR, U.S. Fish and Wildlife, et cetera. So to the extent that that's what your question was referring to, yes.
Regarding the Corps of Engineers, are you familiar with the process of getting a 404 permit from the Corps?
Not specifically, but generally, yes.
Okay. And actually, in terms of a pipeline, there is a nationwide permit, it's called. Is that correct?
Correct.
Okay. And so what the Corps of Engineers does is review what are called pre-construction notices, and then if they're satisfied with those, they issue what's called a verification. Is that correct?
Mr. Schmidt would be able to testify to that, but that sounds correct to me, yes.
And there are certain conditions that are put on that verification, correct? correct?
Potentially, yes.
Do you know what the status of your Corps of Engineers process is right now?
It's in process. We've been consulting with the Corps for a bit of time now. They've been analyzing the route. They've requested specific information, additional details, criteria, etc. I know that we've compiled that, are working to compile some of their requests and getting that back to them. The exact status of it. Again, Dr. John Schmidt's one of our witnesses. He would be much better equipped to speak to the specifics because I haven't personally met with the Corps. I know we have our environmental program manager that's got regular updates with all the Corps districts. We touch Rock Island, St. Paul, and the Omaha districts. So we're touching 3 Corps districts, and they're all working together on our permit. Again, Mr. Schmidt would have the details of the status of that.
And what about the Iowa Department of Natural Resources? What's the process there?
I'd have to, again, defer to Mr. Schmidt, but I know that we have been working with them on, the pipeline route. I think there were a couple potential locations where they would be involved based on the specific site that we were crossing, for example. But I don't have the specifics. Mr. Schmidt would have to speak to that.
Okay. In terms of water crossings, there are several ways you can do that. You can horizontally drill underneath. You can do what's called open trenching. Is that correct? Are there any other ways you can cross a water crossing?
I mean, you can bore it. A jack and bore. You can do a directional drill. You can open cut it. That generally sums it up.
And an open cut means that you dam up the stream and then you dig a ditch below the dam and then bury the pipe in that ditch, correct?
That's a crude representation, of what would be done.
I'm very crude.
So, so we're crossing a number of different water bodies through different means. The vast majority of them are all being drilled.
Okay. And then you just put dirt back over it and let the water run across it, correct?
There's other compaction and other best management practices that would be administered, which most of those I believe are outlined in our environmental construction plan.
Have you submitted that environmental construction plan to the docket in this case?
I believe it has been submitted, yes. My understanding is that there was a data request that had asked for that. I don't recall which one or what the date was, but I believe it has been submitted. And if it hasn't, we certainly can.
Okay. I don't believe it's been uploaded to the docket.
Okay.
In response to Mr. Jorde, I believe, when he asked you about incidents where a city or a local government has asked for the route to be modified, you mentioned the city of Merrill.
Correct.
And that's the example every summit representative always uses. Are there any other examples?
That we adjusted the route at the request of who?
A local government.
I think some of the other examples, we've originally, we draw the pipeline in a straight line across roads because, individual counties have different requirements on road crossing angles and things of that nature, whether you can open cut the road, whether you can bore the road, for example. So we've made hundreds, if not thousands, of changes to the alignment to accommodate those requests. I know that we've worked with county engineers on a couple requests extending drills and doing some other things. So, there hasn't been that many discrete requests that hey, we want you to do this, a lot of the requests are, we just arbitrarily don't want the pipeline. And there's nothing that we can do, quite frankly, with that. So we've tried to work with individuals in counties where we can. Again, the route has matured and is very mature at this point. And so I guess that's my answer.
Well, if the town said, well, you're going through our city limits, or you're within a couple of miles of our city limits where we might want to expand, you're saying you would not move the route to accommodate those concerns?
You know, if, in your example, if we were, a couple miles outside of the city limits, we're working with the landowner that owns that property. We're not going to adjust the route on his individual property to accommodate, a town multiple miles away that he's not even in the city limits of. So, we've really been consulting directly with the individual landowners on their route preferences, as opposed to making wholesale changes to accommodate some individual at the county or town level.
Well, let's talk about that then. What if the route goes inside the city limits of a town? Would you change the route there if the city said, go outside of our city limits?
I think this goes back to the discussion around the ordinances and what authority, towns and counties, et cetera, have in placing a pipeline. Certainly pipelines can coexist inside cities and developments. So that's kind of where I would leave that.
In response to one of Mr. Jorde's questions, you were talking about the Iowa Economic Development Authority, and I didn't catch what their involvement is.
So in conversations that I've had with the routing personnel, the Iowa Economic Development Authority has publicly available information through PDFs that can be looked at that show plan developments across the state of Iowa. And I was told that we utilized that and reviewed that and overlaid that with our route to see if there were any major conflicts within the routing process and outside of wind farms and solar proposed developments that there were not.
Did you listen to any of the landowner testimony over the previous 2 weeks?
I listened to a good majority of it, not all of it.
Did you hear, well, first of all, the director, I guess is his title, of the Economic Development Agency in Charles City?
I did.
And didn't he express that their agency owns land through which the pipeline is planned to go, that is set for development?
That's correct. Yeah, I mean, so we've had multiple meetings with Charles City, and my understanding of how those discussions have gone, at some point there was a verbal agreement that we would be able to work something out. And we're paralleling 2 existing natural gas pipelines that go through that property. We certainly offered up route alternatives on that property. I can tell you that I met with them personally and offered up that we would route the pipeline any way possible to accommodate them, whether that's hugging the north boundary, the south boundary, and ultimately they said that the most preferred route, if it had to stay on their property, would be paralleling those existing pipelines. In the meantime, with all the discussions on that property going months and months and months, and again, there was, from my understanding, a verbal commitment that they thought they were going to be able to work something out and to get an easement signed, that, we were securing easements on all sides of that property. And, upstream and downstream, I think we have almost 10 miles of continuous easements signed with one exception, which is the Charles City development property. And again, we've done everything we can to try to accommodate them and work with them, and ultimately decided that, putting it at, paralleling the two existing pipelines was the most favorable spot for them in what they told us. And I know there's a lot of different people involved on that board, and there's probably differing opinions of that.
So knowing that the Trail City Development Corporation, if that's the proper title, owned that land and wanted to develop it and didn't want a pipeline there, you went ahead and acquired land on both sides, prejudicing the decision about what to do with that development property, correct?
Again, there was conversations over an extended period of time that, we fully believe we would be able to come to a mutually agreeable solution on the route and the placement and the pricing and everything. And, again, it was kind of back and forth that entire time. And so the route was placed there following existing infrastructure. There's Mid-American pipelines going right up into the middle of Charles City with development all around them. So those pipelines have not precluded development. They obviously bought that property with two existing pipelines crossing it. So they understood that they obviously thought that pipelines would not stop development. So there's a lot of different things that were involved with that property, and, we're hopeful that we can, work something out with them.
So in your view, a pipeline's a pipeline?
A PHMSA-regulated pipeline built to a certain design, construction, operation standard, to me, is very similar, no matter what the commodity is going through it. I mean, obviously, each commodity has its own specific, design criteria, et cetera. But pipelines, to me, are very similar, if they're built to those same standards.
But do you think there is some reason why a carbon dioxide pipeline is called a hazardous pipeline?
I can't speak to exactly why it was called hazardous. It falls under the hazardous liquid pipeline standards for PHMSA.
Thank you. That's all the questions I have.
Thank you. Okay, as luck would have it, Farm Bureau is next. And I assume you've got more than 23 minutes worth of questions?
That is correct, Chairperson.
Okay. Unless any of the parties are vehemently opposed to it, I think it probably makes more sense to break now and then go to confidential and let Farm Bureau pick up tomorrow rather than break your questions over a day.
Your Honor?
Yes, sir.
My questions are going to last about 5 minutes, and I am not allowed in confidential.
Oh. Gotcha. Go for it. Okay, Mr. Murray.
Thank you. My questions focus on routing as well, okay?
Yep.
As I understand it, Iowa Farm Bureau's witness, Johnson, has a chart showing that there's about 687 pipeline miles in Iowa. Would you agree with that statement?
For our project in particular?
That's right.
Yes, that's generally right.
And your chief operating officer, Mr. Powell, testified that Summit does not intend on amending the application as to route. Would you agree with that statement also?
Yes.
I think, correct me if I'm wrong as to Summit's position, but is it that Summit's proposed route is the one and only route that Summit is proposing unless the IUB orders otherwise?
If the IUB orders that we make a change in the route, certainly we would accommodate that.
Iowa Code Section 479B, I think, 5, states that a petition for permit shall state all of the following, and the 6th subsection states the possible use of alternative routes. Can you confirm today Summit's petition to the IUB shows no possible alternative routes over the 687-mile pipeline. Is that Summit's status of its petition today?
Objection, Your Honor.
State your objection.
Misstates the content of the petition and its exhibits.
Mr. Ray, can you rephrase?
Please state Summit's petition inclusions as to alternative routes.
So the existing pipeline alignment is the route that we're seeking a permit for with the IUB. Certainly early on in the routing process, there were different route alternatives considered. There was, an analysis done with our GIS consultant to look at those high level before the preliminary route was established and our corridor was established. Outside of that, I can't speak to any other kind of alternative analysis that's been proposed to the board.
I believe you've.
Sorry, Mr. Ray. Mr. Schovanec, can you? I know it's difficult when you're sitting right between the two of us, but just speak into the microphone. You go ahead and look at Mr. Murray, but we just need to be able to hear you.
So as it relates to minor or major route changes, is there anything that is specifically proposed to this board as alternatives?
Not that I'm aware of.
So I guess I'm trying to understand, and maybe I can rephrase my question here. Can you confirm today that Summit's petition to the IUB shows no specific possible alternative routes?
Objection.
State your objection.
I believe that this individual, I'm sorry, I gotta wait for that, don't I?
Same objection. Also, objection as to legal conclusion. I'd also suggest that here today is not the petition that was filed months and months ago.
Okay. Mr. Murray.
I believe this witness has testified as to the fact that there are no specific alternative routes. I just want to confirm that those alternative routes that are not specifically identified are also not within Summit's petition, if the witness has any knowledge of that.
The existing alignment is the only route that is part of our petition.
Thank you. I have nothing further.
That was exactly 5 minutes.
How about that?
All right. So we will rest with Farm Bureau and push Farm Bureau till tomorrow morning. We'll start right off with you at 8 o'clock. For right now, let's go ahead and take a 17-minute break until 3:30, and then we will come back to Mr. Paroli in confidential session. And so we will need to identify and remove all those who are not covered by an NDA.
Okay, Your Honor, I have a question
Yes.
on that.
Yeah.
For anyone that isn't presently covered by an NDA, is there a mechanism for them to sign an NDA and become a covered person or party?
Good question. Okay. Yeah, you'd have to talk to Summit.
Okay,
Do we have a mechanism to do that efficiently or quickly, or?
I could certainly email one right now.
well, I guess what I'm getting at is obviously, council who have already signed it have got it. What I'm saying is for people that aren't council that are willing to be bound by confidentiality, what about that?
The offtake agreements pursuant to the board's order are subject to attorney's eyes only. So only attorneys could view them, attorneys on behalf of the parties.
So no parties are able to see them. I guess that would be my objection, that it's the party's case, not the lawyer's case. So if we're going to be having a mechanism to discuss them in confidentiality, I think any party should be able to subject themselves to the NDA and be a part of that process.
Your Honor, I think that there's good reason that was established that led the the board to agree to an attorney's eyes only condition. There are certain ethical restrictions on attorneys and certain consequences for attorneys that provide an additional layer of protection that the materials being discussed merit and warrant, and that is a critical part of the agreement that someone was willing to enter and entered with the represented parties.
Okay. Thank you. Objections or comments or no?